Well, good afternoon, everybody. There's always that moment when the room suddenly goes silent, which obviously means we have to do something. So it's the last session of this very wonderful conference, which has been very impressive and very enjoyable. And so we're going to conclude by hearing from 5 of the national competition authorities. As I said in my own presentation yesterday, when we look at the enforcement of 101 and 102 in the EU these days, it's important not to lose sight of the fact that about 75% of all enforcement is done at NCA level, and the NCAs produce lots of very innovative and interesting decisions. So I think it's going to be extremely interesting to hear what the people here have got to say. So on the panel, we've got Llanos there, the head of the Greek authority. Next to me is Nuno Rodrigues, the head of the Portuguese authority. To my left, Elisabetta Jossa, commissioner with the Italian authority. Next to her, Fabienne Siridi Garnier, vice president of the French authority. And I hope, yes, I can see online, we've got Natalie Harsdorf-Borsch, who is in Austria, unfortunately unable to be with us today, but I'm glad I can see you there. So what we thought we would do is, or I would do, is to give each of them 7-8 minutes, something like that, just to tell us what are the interesting issues that they're engaged in at the moment in their respective authorities. I think we'll hear quite a lot of commonality, because obviously they're all gearing up for the DMA and issues like that. But also different authorities face different pressures and whatever at any moment in time. So let's hear from them. And then, once everyone has presented, I will then moderate a discussion and select particular topics that I think are particularly interesting. So we're going to begin with Nuno. Over to you.
Many thanks, Richard. Many thanks also to Lear for this invitation. It's always a pleasure to be at Rome. It's such a lovely city, and to be able to discuss with all the competition practitioners, with my colleagues here from the competition authorities. Well, I'm the youngest one. I just took office half a year ago, so I'm kind of a trainee in terms of head of agency. So I'm starting here, although I was, and I am still a law professor in competition, so many of the things that I was catched in the Portuguese Competition Authority I already knew from the past. So I already knew that competition authorities were kind of gods, and that competition authorities were called to solve the world problems. All the world problems are being solved by the competition authorities, like inflation issues, labor markets, privacy, environmental sustainability. So it's all up to us. So we try to disguise, saying, no, we are not gods, we are not dealing with that, but at the end we are. So it's our role trying to solve all the world problems. That reminds me of that figure of that Indian goddess Shiva, a god with lots of arms. So that's where we are right now at the moment. So at the Portuguese Competition Authority, the same as my colleagues, we are called to, I would say, different type of challenges. So we have what I would say external challenges and internal challenges from the Competition Authority. From these external challenges, I would mention, a common one to all of us, which is the DMA that Richard has already mentioned. Of course, DMA, it's an important new instrument tool for the European Commission. It's not an instrument for the NCAs, but we have to check the interaction that will happen between the NCAs and the European Commission, because the NCAs will be called to help the European Commission in the ongoing investigations that the European could be called to do in the DMA. We either know the gatekeepers that were called by the European Commission, and now we'll see how it will be developed by the European Commission. But we cannot forget that the NCAs can still apply 102. So even though the DMA exists, we are still we can still decide cases under Article 102. So let's not forget about it, and we have ongoing stuff in this area. Another thing is Article 14 of the DMA, according to which the gatekeeper should report to the European Commission any intended concentrations within the meaning of the EU merger regulation. And so the NCAs should be informed of the merger plans by the European Commission through the European Competition Network, the ACN. And so this might cause some problems because they may then consider referring those deals, the NCAs, to the Commission under the referral system of Article 22, which has been so much discussed about, namely after the Illumina Grail case. And this may cause some legal uncertainty with the application of the DMA. Let's see how the European Commission will deal with that and how the relation with the NCAs will be developed in the future. Another topic that was talked this morning here at the LEAR conference is the application of the foreign subsidies regulation. This is also new. Of course, this is a new tool for the European Commission, but also there is an interaction with the NCAs that we at the Portuguese Competition Authority and the others will be called to do. At the ADC in Portugal, we've been following this topic closely, the application of the foreign subsidies, because, namely, in merger operation, we could be called to cooperate with the European Commission in this field of the application of the foreign subsidies regulation. Another external challenge has to say that we are called to do has to do with sustainability and the relation between competition and environmental protection. Of course, this is an ongoing discussion. It's something that there is still no, I would say, consensus on this, but much has been done in the latest years. We all know that the European Commission has just published the revised guidelines on horizontal cooperation agreements, which includes a chapter dedicated to sustainability agreements. So this new sustainability chapter that was included in the revised horizontal guidelines strikes a good balance and a positive development that should be looked carefully by the NCAs. The guidelines provide clarity, so business needs simple and clear guidance, and this happens with the guidelines. And second, of course, that sustainability agreements may be useful to promote the green transition. And we are following closely these guidelines in the Portuguese Competition Authority. Of course, that we cannot forget that there is always a risk that sustainability claims could be a smokescreen for cartels, as it has been seen in the past cases. Therefore, we should not lose sight of the possibility of greenwashing by companies. So it's always a balance that we have to do. Another topic is the relation between competition and privacy. The interaction between those policies could be understood as complementary or, at the same time, conflictual. For example, of course, competition and privacy are complementary when data protection is a parameter of competition. And we've seen that just recently, like in the famous Facebook case by the European Court of Justice in the case of the Bundeskartellamt. But in some circumstances, however, privacy antitrust can be and can have conflicting goals. For example, imposing interoperability or data sharing obligations as antitrust remedies may promote competition at the expense of privacy. And data protection legislation could also favor incumbents. So that's a risk that we have to look carefully here at the Competition Authority in Portugal. Another topic that we are trying to develop in Portugal is following the European Court of Justice case, the Facebook case, is trying to promote our relation with the Data Protection Authority in Portugal, trying to work in a bilateral way and trying to see the role of each one and how can we help in our roles to protect privacy. In terms of internal challenges here, now talking about the Portuguese Competition Authority, ADC, well, I've talked about the DMA. We have a digital team that is dedicated to digital markets and also to the implementation of the DMA that has been working closely with the European Commission. We are always looking for digital markets. We are now looking very carefully for artificial intelligence and namely for the problems that the so-called generative AI, which I think it will be the next big thing, will pose in the future. We are trying to issue a paper that will come out, I suppose, in the next month or next 2 months, is about the generative AI. So particularly, I do think that this will be the next big thing, the next competition issue for the coming years. And I'm talking not only about the artificial intelligence, but particularly about generative AI and the ecosystems problems that it may pose to competition. About the topics that we've been working at ADC, one of the topics, and I suppose it's quite famous, and Richard knows it well, it's about the hub and spoke investigation that we have had in the past. We had 13 investigations that were already concluded with hub and spoke cases. Just recently, and I was already in the office in April, we have decided another case of hub and spoke, and there was a fine of 16.9 million euros to 3 supermarket chains and a supplier of beauty and personal care products for hub and spoke agreement. And another topic that the ADC has been focused, and I do know that people in competition world have been closely looking at this, is labor markets. We had a decision that I suppose is kind of well known in the year 2020 of labor markets. It was a case of sports. It was an agreement, a no-poach agreement involving the Portuguese professional football leagues, and it's also why one of the reasons because it became famous, because we have so much soccer in Portugal that everyone knows this case, and that involves 31 sports companies. So the no-poach agreements have a negative effect on market because they decrease mobility and they reduce innovation. So this was a very important decision in our understanding for raising awareness for the prohibition that the no-poach agreements have in terms of competition. We have also ongoing investigations in labor markets. I cannot speak about them, but of course they have to do also with no-poach agreements and also with wage fixing agreements. And I do know, like, for example, in the famous Department of Justice merger guidelines that are to be published, one of the chapters is about labor markets, namely the impact of labor markets in merger operations. So there are also cases that were decided all over the NCAs in Europe concerning no-poach. I remember like Lithuania, Romania, many, I would say, small and medium economies, not so big economies. Maybe the French authorities can speak about that because we haven't seen no-poach agreements being dealt just recently, as far as I know, in Germany, but maybe they are investigating, I don't know really. I would highlight another topic from my authority, which has to do with recommendations that we've been doing in terms of inflation. This is also a decision that my board of directors and myself were very involved in this year, because at the end of all these hub and spoke cases, the 13 cases that I mentioned, we decided to issue a recommendation, a set of recommendations raising awareness for competition policy among business along the value chain of consumer goods, that try also to make some awareness and some advocacy for companies about what were hub and spoke cases, how can they prevent those situations, and also trying to help to reduce inflation. Of course, competition cannot reduce inflation in the short term, but it can help to reduce inflation in the medium and long term. So again, we try to solve all the world problems and also this. So again, Richard and I try to comply with your orders. I was given like 8 minutes, so these are my 8 minutes of topics that I wanted to present to you. Thank you so much.
Well, it's absolutely wonderful, and on time, and all the big issues have been raised there, and I know some of the other speakers are going to talk about them as well, and then we can come back and discuss them in due course. So that was fantastic. Shall we go to Natalie now?
Sure, thank you. I hope you hear me well. It's a great pleasure for me to speak to you today. I want to talk about a bit, to some extent similar, but to some extent very different topics from Nuno. So one issue I want to touch upon is that in the jurisdiction in Austria, we have experienced now the interplay between different enforcement tracks, and that has led to ECJ proceedings also. I don't know if you remember, but the Nordzucker case stemmed from Austria, which was then dealt with before the ECJ together with bpost. And I can say that we reached a settlement in this case now before summer with several million euro fines in the industrial sugar industry. But building on that case, now we have another ECJ case pending, again, on the interplay between different enforcement tracks, and this time, not like Nordzucker, it's not between different competition authorities from different member states, but it's about criminal proceedings in Austria and competition law proceedings in Austria. And I think a lot of questions are coming out of this now in Austria, because we've been extremely successful in building up the fight against bid rigging. Last year alone, we had almost 100 million euros in fines in bid rigging cases. They just keep coming, talking about construction, waste management, and other areas. And I think we've developed very good investigation tools to uncover bid rigging, but now that's leading to a number of interesting questions. And the question now pending before the ECJ concerns the, I think, almost famous construction cartel in Austria now, where the public prosecutor is investigating almost over 600 individuals. And here the question is whether the leniency statements and the settlement submissions that have been submitted to us in the cartel court for the purpose of competition law proceedings, to what extent are they protected somewhat vis-a-vis the prosecuting authorities in criminal investigations, but also to which extent the information in those documents is protected. So not only the document itself, and of course it also relates to the question, what about third parties that have access to the criminal files? For example, possible damage claimants, to what extent should they have access to those files? So it's a pretty critical proceeding for us that is now pending before the ECJ, because it will define also the way we work together with the prosecutors on the criminal track in Austria, where we have two tracks. Another question also coming from this two-track investigation sort of is that within the construction cartel, we had a hybrid situation where we already had settled with some companies and others not. And one major company had settled with us and was also a successful leniency applicant at the time, had settled for 45 million euros. That was a closed case before the cartel court. And then via the criminal investigation side, we were informed that some new information had come up, which in our view put into question the full cooperation of this leniency applicant. And we asked the cartel court to reinstate the case, so to open up the case again against this company. And this went up to the Austrian Supreme Court. And before summer now, the Supreme Court decided, yes, proceedings can be opened again. And now we're starting again proceedings at the cartel court level against this company. And I think this will be another interesting question. And I've heard from other countries that it might also not be a completely clear issue there, how you deal with such a situation. At least in Austria now, it has been decided that you can reinstate proceedings in such a scenario, even if the case was already closed. And we'll see now how the cartel court deals with this situation where a leniency applicant possibly didn't fully cooperate with the agency, and what happens with the fine, and so many open questions there. And also we have two cases where also the nebis in idem question, which was already dealt with in Nordzucker, might also come up again regarding in the context of these two tracks, criminal and cartel competition law enforcement. So the ECN Plus directive and what's stated there on the interplay between criminal and competition law proceedings, that this will be tested in these cases and also before the ECJ. So I think that's might be something that is of interest to also other authorities other than the Austrian Competition Authority. Coming to a completely different topic, apart from many hardcore cartel cases, we also have a number of interesting sector inquiries ongoing. One of them in the food sector, which is a sector of particular concern to us. We've seen very high price rises in this area. Austria is faced with high inflation, as many other jurisdictions. And we opened a sector inquiry. That's one track. On the other hand, we also did a mapping exercise where we found out that we should be looking into food delivery platforms. That's another food track, let's say. And we published a recommendation to the policymakers and to government to facilitate price comparison platforms in Austria to get better access to food pricing data. We published a paper on that, and the Minister of Economy announced that they will put forward a legislative draft implementing our recommendation, which should provide price comparison platforms to get immediate access to the pricing data, so to the prices that the supermarkets are setting, so that consumers can easily compare prices for food products. And in our view, this transparency will lead to more competitive pressure and will help in this regard. Concerning the sector inquiry into the food sector, there's a lot of interest in the public sphere in Austria on the sector inquiry. And today I read an interview by Andreas Mund from Bundeskartellamt saying that they completely rely on the Austrian sector inquiry into the food market. And so they referred to us. So now we also get pressure from Germany, apparently. They will also rely on our results. So we're trying to live up to that, and we will publish the results end October. The main questions are where in the food value chain did these prices increases go to? Did they lead to higher profits? Somehow agreed inflation. But we are also looking into, in general, how different competitive factors have evolved in the food chain in recent years. We're looking at concentration ratios in a wide range of food categories, 34 food categories that we're looking into. We're looking into the development of private labels and also in the role of online retailing. And another final issue we're also looking into is the topic of UTP practices. Austria is an enforcement body against UTP practices. And part of the sector inquiry is also to find out how widespread these practices are. Regarding UTP, I can also announce that we will, it looks like we will bring the first cases before the cartel court still this year in the fight against UTP practices. It's a rather recent area for us to enforce, but I think we're on good track there. Last but not least, we also we have a common task force with the energy regulator in monitoring, I would say, specifically the electricity and gas markets. And I think it's a very positive example of a country where the energy regulator and the competition authority are not integrated in one institution, where we were able to set up a common task force and really work closely together on these issues. I think that's the best practice. Coming back to some maybe of Nuno's issues, as you are well aware of, Austria is, I think, one of the very few countries in the world where, regarding sustainability, not only the authority provided new guidelines, but also the legislator took the decision to introduce an out-of-market efficiency defense into our competition laws, national competition laws. Building on that, we published guidelines, and they've been very well received by the industry. We've had several positive consultation cases building on the new law and on the guidelines. That being said, we don't see that they are being used in a widespread way. So I think they're useful, but they are not a game changer. And I think that's, of course, also due to the fact that Austria is a smaller jurisdiction, and for many of these corporations, you would have to apply European Union law, but it still sets a certain example in my view. Regarding digital markets, Austria sits in the advisory committee for the DMA. I'm elected member to the high-level group of the DMA. We are a public enforcer for the P2P regulation, so we have a role in this regard. However, we try to focus our national activities in the sectors where we see that they will not be dealt with under the DMA, and one of them is the food delivery market, where we have an ongoing sector inquiry. I think it's going quite well. We just received answers from almost 2,500 restaurants that we send RFIs to. So I think this sector inquiry also shows that national activities, they go hand in hand with the ones at the European level, just dealing with other cases and sectors. I don't know how I'm time-wise, but I think I'll wrap it up here. Thank you.
That's ideal, Natalie. Lots of similar issues to Nuno, but also some new ones. There's stuff about criminal proceedings, leniency, hybrid settlements. I can tell you in the UK, these issues have been incredibly difficult and have caused many, many problems. They're very difficult areas. Let's move on. We'll hear from Elisabetta next, and I think you're going to use a slide at some point in the course of the presentation.
Okay, thank you, Richard. It's really nice to be here at this panel. Thanks for the invitation to Lea. So I thought I will very briefly talk about three things. So first, some numbers on our activity, just to set the scene, then some highlights on our cases and focus on inflation. And then perhaps few remarks on the application of our new tools. So here are some numbers. So we monitor input and output quite carefully and look at how things go over the years. So in terms of number of cases, we see these are pretty stable. Perhaps there is an increase. The number of agreements are 10, abuse is 6 cases, 5 merger phase 2. We have a dual competency, so we have a lot of consumer protection cases where we have the possibility to accept commitments and to impose fines. So we reached 117 cases. We also do a lot of advocacy to parliament, government, and public entities. This year, there were 62. We ran an internal review which made us slightly modify our approach, and that we can see it's been effective in a minute. I would like also to mention that the authority has hired about 40 new officers, but we remain a small authority compared to the large authorities in the sense that we are about 300. But the productivity per case handler is extremely high, 2.9. And this is important really to remark because it's a sign of this sort of sense of mission and identity of our officers. The fines have been decreasing in competition, relatively high in consumer protection, and we now collect data also showing that in consumer protection we refunded the companies refunded 737 million. We run every year an OECD methodology that's been expanded in a couple of directions as we consider also non-cartel agreements and also commitments, and therefore we found that our activity has helped to achieve customer savings short of 1 billion. The trend more or less is the same as the last few years, and it's a kind of is higher than in the previous 5 years, but more because of a change in the methodology. Advocacy, as I mentioned, remains quite effective. We run internal checks to see what's the success rate of our recommendation to public entities, and this is well above 63%, which means that the public body has fully or partially complied with our recommendations. So I thought of trying to give a reading, a sort of horizontal reading across some of our intervention in the last year or so. We, as Ioannis and Nuno mentioned already, and Natalia mentioned, we are always under a lot of pressure to try to respond to short-term crisis on top of this, of our long-term activities, and therefore there's been a lot of debate among authorities as to what we could do for mitigating the impact of inflation. Of course, inflation is not part of our mission. We are not the authority that should tackle it. However, as emphasized by a study in 2015 by the European Commission, competition policy interventions can have an impact on inflation. In particular, they found that it triggers 0.77% points reduction in markups, which translates in a 0.21% decline in inflation. We had last year in New York a very nice and last week a very nice and interesting debate among authorities on what we can do and how competition may affect inflation in the short term and in the long term. There are these effects identified by economists. In the short term, the pass-through from a cost shock is maximal under perfect competition. But competition can really help in the long term because as you have variety and more entry, you can have access to different technologies and suppliers which can mitigate the impact of inflation. That's the channel through which competition can help. So our day-to-day activity, normal activity, I would say has perhaps also contributed. We've had 3 cartel cases one on road fuel in Livigno, one on biofuel, which is ongoing, and one on energy surcharge imports, which is also ongoing. And we also run 3 excessive pricing cases still ongoing on district heating services, where the energy cost shock was leading to higher prices, despite some of these companies using mainly waste. So we have also, like Austria and other countries, run a market investigation in raw fuel to see where were the problems there. We also were asked by the government to monitor a pass-through of a windfall tax on profit, and this is still ongoing in the energy sector. We had to evaluate 2 important mergers, one in the electrical power generation involving the incumbent Enel, which was blocked, and the other one in the raw fuel and refining assets involving 2 large companies, IP and ESSO, which was recently cleared with conditions. In terms of consumer protection, we've been also quite active. There have been cases just closed with commitments on the issue of price transparency at petrol stations. So lots of things that do not tackle inflation directly, but certainly have an impact on prices and somehow showed how we were looking at the energy crisis very, very closely. We have recently been endowed with new tools which we're using. So first of all, the authority now has the possibility to ask firms to notify within 6 months from closing mergers below threshold, provided some conditions are met. So we have issued new guidelines in 2023. We have a screening project to be able to detect these potentially problematic below threshold mergers. And we have just opened 2 cases where we request notification to the company, one following a whistleblower complaint and the other following a voluntary notification. We have also used our new power on abuse of economic dependence, which allows to consider a platform providing key intermediary services as platform where there is a rebuttable presumption of economic dependence, and we have a case Meta-CI that's still ongoing. We have also, since February 2003, opened up a whistleblower tool which allows complainant to communicate with us without us learning their identity, and we have opened already 2 cartel cases following some of these complaints. We've also issued new guidelines on settlement, which is again a new tool which we have received. And I just would like to highlight some of the sort of perhaps more interesting cases that we have closed or are ongoing this year, and the issues that I see as most interesting. So we have this case just closed with commitments on Google data portability. It's a very interesting case, perhaps because it shows an attempt here to create a market for data. A small startup was asking users to give the consent for the company to get their data off Google and then sell the data to a third party in exchange of a share of the revenue. So really market for data. The outcome of the commitments have led to an automation of the data transfer. Then we have the ongoing case MetaCI, which is the first case, as I mentioned, of abuse of economic dependence by digital platform, where bargaining strategies play a crucial role. Like France and Germany, we have the Apple app tracking transparency case, which is very interesting from the perspective of the intersection, as mentioned by Nuno, between privacy and competition. Then we have open, I would like to mention here, it's a consumer protection case, but I see it as a very innovative one as well, a TikTok case, which has to do on personalization that may cause harm to vulnerable consumers, with the possibility for the company to monetize on users spending time on the platform. We had last 2 cases, and then I conclude, a Bancomat case where we had to run an analysis of the price effects under a new remuneration scheme for ATM withdrawals, and run a very complex, innovative IPS economic analysis. We assessed the incentives to increase prices for parties that were present at different level of the supply chain. Perhaps if I have time, then I can talk about, okay, so perhaps I'll just mention a few things about the DMA.
Sure,
and of course, so we are ready for this challenge. There has been a lot of discussion as to whether, the DMA was taking away power and the role for national authorities. I think I can say that most of enforcers, certainly us, believe that the DMA, which is a regulatory approach to some digital issues for CPS services, will play a complementary role to competition policy, and we are ready again to set far-reaching precedents, which we know will inform and allow the DMA to evolve. We have already benefited in the past from very good collaboration with the European Commission. Also in the Amazon FBA case, we don't therefore fear at all the intensify of this collaboration for making sure that Article 102 and DMA run on parallel but interconnected channels. And in a sense, I believe that the interdependency that is being required by the intersection between issues like privacy, consumer protection, and antitrust, or the new interdependency will arise with all the issues related to artificial intelligence, are a way for authorities to respond to a world where issues are getting complex and may need to be tackled from different authorities or regulators. The history of the Italian authority, we've seen this very clearly with many cases. I cannot mention here, but I could mention later. where the sort of collaboration with sectoral regulations, so on top of collaboration with the Commission, has always been extremely fruitful, and therefore we think that even sort of this interdependency is a good thing. Thank you.
Very good. Thank you, Elizabeth. Should we go straight on to Fabienne and hear from the French perspective?
Thank you, Richard, and thank you for giving me the opportunity to speak at the Lear Competition Festival for the second time. I'm very pleased to do that. You gave us 8 minutes. I will try to keep this time frame. I say I will try. First, I will give you an overview of the French Competitions Authority activity last year, and then I will give you some general considerations. Firstly, maybe some few figures from 2022 to illustrate our still high level of activities. We issued 292 decisions and opinions, including 257 on mergers. It's not a record, but we had a record of notifications. We also issued 9 opinions and 13 sanction decisions. Excluding merger decisions and regulated professions, the economic sectors in which the French Competition Authority has been most involved in descending order is energy, then maybe more exotic, the French overseas. It's not sufficiently well known, but this sector, and in particular the fight against the high cost of living in these territories and the maintenance of competitive markets, represent a significant proportion of our activity and, I would say, energy. And other sectors are health, art and culture, issues relating to the audiovisual rights of football and the cinema have also kept us busy. We imposed 468 million in fines, which is a rather low level compared with our average, around 720 million, but which I always compare with our annual budget, around 23 million euros. This may seem a good investment for public authorities. For every euro invested, they get 20 euros back. We have had a consistently high rate of confirmation on the merits by the courts, depending on the year, between 77% and 100%, despite some painful decisions. But a tendency by the courts to lower, sometimes significantly, the amount of penalties gives us some cause for concern. Not that I dispute the very principle of judicial review, that would be the last straw for me as a judge, but because the signals sent out by the courts in certain cases seems to us to weaken the dissuasive effect of penalties. I just give you one example, the Apple case of 2020. When we set a penalty, we apply a coefficient of increase when the company fined belongs to a large group. Apple had been subject to a 90% increase, but the court reduced this rate to 50% on the sole grounds that, I quote, the 90% rate was disproportionate, without any more justification. These are the main figures. And as it is difficult to choose from among all the decisions and opinions we have issued, and of course, if you want to learn more, you can visit our excellent website. I will limit myself here to mentioning 2 examples. My first example is the cloud study we issued in June 2023, and which will be soon available in English. And this study illustrates, in my opinion, the necessity for national competition authorities to scan the horizon and anticipate potential competition concerns in emerging markets. This study, which took 18 months to complete, highlighted the role of certain key players, the so-called hyperscalers, and proposed an analysis grid to identify possible relevant markets and practices likely to restrict competition, such as cloud credits or egress fees. It also showed, and I think it's interesting, that the existing tools could effectively tackle these practices, whether under competition law or law on restrictive practices, and that the market failures identified could be addressed by texts currently under discussion, such as the Data Act or the French bill on the digital space currently under discussion. My second example, the Meta AdLooks interim measures decision of June 2023, again, illustrates the ability of competition authorities to act quickly, which is very important. In this case, AdLooks brought a case concerning practices in the advertising verification sector. AdLooks considered that Meta had abused its dominant position by refusing access to some partnerships and by failing to define criteria for these partnerships. The authority, using its power to impose interim measures, which incidentally are a very valuable tool, especially because the French standard is less demanding than the European standard. There must be immediate harm with no need to establish a prima facie finding of an infringement. So we enjoin Meta, which in our view holds a dominant position on the market for online advertising on social networks and online display advertising, to suspend the application of the criteria of access, to define new criteria within 2 months, and to facilitate the integration of AdLooks if its application for partnership is accepted. And by some kind of miracle, this decision was not appealed by Meta. I move on now to some general considerations. First of all, I would like to emphasize that the French Competition Authority has, like I think every authority, has to work in a constantly changing regulatory environment. Richard, you told us yesterday that it was a very complicated puzzle, and I totally agree. It is a reality in terms of what is known as soft law. We have published new procedural notices in a very short time, rejection for lack of priority, compliance, and we will soon be publishing one on leniency. It's also a reality in terms of national law, the laws regulating digital technology, protection of privacy, designed to combat inflation or regulate trade negotiations. And I have to say that the French legislator is indeed very inventive. And of course, it's obvious in terms of European law, which, as you all know, has been particularly active in recent years. And in addition to this inflation of norms, there is also inflation in the ordinary sense of term, and more generally, the crisis context in which we have been operating for several years. As Benoît Cœuré, our chairman, has already pointed out, fighting inflation is not an enforcer's primary task. However, by breaking up cartels and condemning vertical restrictions that have a negative impact on the market, as well as abuses of dominant position, competition law makes it possible to fight rents and thus restore purchasing power to consumers. It's true that in France we haven't identified cases of excessive price, particularly in the food industry. We receive such complaints, but we had to dismiss them. I have also to say that the case law in France about excessive prices is very restrictive, and it's very difficult to build a case on this point. But we have strived to contribute in industries which are the most prone to inflation, such as energy. For example, we took 2 decisions in 2022, sanctioning historical monopolies for abusing their monopoly infrastructures. On the advocacy side, it's fair to say that most of our efforts have been defensive and devoted to fighting what we think are bad ideas. This has been particularly true in the food sector. In France, politicians' gut response to any income shock is to regulate prices, to regulate quantities, or both. And every time the authority has expressed skepticism regarding price control and rather encourage, of course, market mechanisms. But despite these observations and the many criticisms leveled at these mechanisms, in 2023, a new law in a similar vein was adopted to regulate prices and commercial negotiations down the food value chain, which maintains and more worsens measures as increase at a loss threshold or regulation of discounts. The last comments I would like to make at this stage, if I get the time, relate to our priorities, which, unsurprisingly, it's not very original, concern the digital sector and sustainability. Sustainability, as you all know, has quickly become a major issue for most competition enforcers, and several competition authorities have already taken concrete initiatives in that sense. We, at the French Competition Authority, are currently working in order to factor sustainability considerations in every dimension of our action. On the enforcement side, we should make it clear to companies that anti-competitive practices that actively hinder the ecological transition will be sought out, investigated to the full, and the case being severely punished. This was, for example, the case in the floor coverings cartel, sanctioned and fined for more than 300 million. But on the other end of the spectrum, we are also eager to make sure that we provide the right kind of encouragement to those undertakings that really seek to move towards a more environmentally friendly behavior. The priority is now to identify practical cases. In this framework, we are very much inviting companies seeking for advice on eco-friendly projects to come to talk to us in an informal way. We know that the lack of legal certainty can be a burden for companies, especially when exploring new territories, and so we are more than willing to provide some comfort when we can. And by the end of 2023, we will publish for public consultation a procedural framework to guide companies which are seeking advice. And we also use our advisory remits to explore how the growing importance of sustainability is shaping the competitive landscape. And we recently launched 2 separate market studies in the transportation sector with a particular attention to intermodal connections and the development of charging stations for electric vehicles. In the digital sector, a lot of things have already been said, so I will be brief. I just want to remind you what, again, our chairman recently said. He pointed out that the growing number of regulatory initiatives at the European Union and national level in the digital space is, I quote him, pretty messy, and you need a little bit of discipline. In this context, of course, one of the main challenges will be the coordination between this set of rules and other sets of rules, of course. To conclude, I would say that we are living through a period that is both difficult and exciting. High expectations from policymakers and stakeholders regarding the economic crisis, emerging technologies such as generative AI, which challenge our ability to keep pace, meeting the challenge of sustainability, navigating through new sectoral regulations, and the return of industrial policy. Thank you for your attention.
Thank you very much, Fabienne. Extremely interesting. Now, we come to the final panelists in a moment, Yanis. Let me say, it looks to me as though we're going to have a good 25, 30 minutes for questions, which is, or for discussion, but also for questions. So please, if anyone does want to ask anything in due course, stick your hand up. Is there a roving microphone in the room? If people, there, yeah, great. So it would be very good, while you've got 5 competition authorities here, to have some input from all of you. So Yanis, let's hear from you. Obviously, I think quite a few of the issues you want to talk about have already been touched on to some extent, but let's hear your thoughts on this from a Greek perspective.
Sorry, thank you very much, Richard, and thank you again to Lara for the invitation another time to Rome. It's a pleasure to be here. So I will just start by a little bit explaining the activity of the Hellenic Competition Commission the last year. It has been quite active. I mean, we issued a number of decisions, in particular in an important cartel in the port services sector with a little bit of 5 million euros fine. We had a number of RPM, ERPM, MAP type of cases in the vertical field, and also quite important 1 or 2 abuse of dominance cases. We issued a fine of around 10.2 million euros to Coca-Cola for naked restrictions as well as oral exclusivity agreements, and we just announced this morning a fine of 24.5 million euros to the monopolists in the gaming market for using tying agreements in order to expand their monopoly and their market power in secondary markets like payment systems, payment services, sorry, and sale of telecom cards. At the same time, we have been very active in terms of investigations. We are, it seems, according to White & Case statistics, the #1 competition authority in Europe in number of down raids. Actually, we have around 38 down raids in the period of 2018 to 2023. And we have been using since 2021 the whistleblower tool, which actually, because of an important public campaign we did on national television, we have so far received more than 205 kind of leads. Many of those are not necessarily very relevant, but a quite important part of them is, and we have a number of investigations that have been completed because of this specific type of tool. In particular, you know, in some cartel type of activity. At the same time, we have been, it was a quite interesting year also with regards to merger control. We approved this summer our first failing firm defense ever in a case involving the maritime transport services, like it was a merger between the first and the third largest maritime transport services in the country. And also we have adopted remedies in with regards to a merger in the online delivery sector. The important issue here is that we very much focus on the use of data and the anti-competitive use of data, and one of the remedies we impose is a data unbundling remedy. That is in the Delivery Hero type of merger case. And we relied a lot on conglomerate effects actually to achieve this specific result. So at the same time, I think, and following up a little bit what Natalie was saying, it's interesting to see a little bit the interactions between the criminal prosecution and the administrative enforcement of competition law. In Greece, actually, we have been trying during my presidency to promote criminal enforcement. I think it's probably the ultimate deterrent tool that you can actually have. So usually what we do is when we issue the statement of objection, we send it immediately to the prosecutor so that they can start actually a criminal offense kind of investigation. However, in our law, there is a possibility in case you have a settlement or in case you have a leniency, of course, to avoid this kind of criminal prosecution. And this is usually a very good way to get leniency applications. Actually, not so many leniency applications because we haven't been successful in leniency applications, but actually settlements. So I think this is quite interesting here. But the information doesn't go only from the competition authority to the criminal prosecutor, but it can actually be the other way. So, for instance, in the context of this cartel in the port services sector, we actually got evidence that came out of the criminal prosecution, so that we use in a certain way for our investigation and in order to conclude the settlement at the end in this context. So I think there can be like interesting cross-fertilization in this context. Following up a little bit on other areas of let's say less traditional enforcement, we have in Greece actually the tool that of market investigation references is exactly the same as in the UK. Actually, was copied by the Enterprise Act 2002 in our law in 2005. And it hasn't been used very much. I mean, it was used in 2008 and 2009 in the fuel sector, but I have been a very intense user of that tool the last 3 years. So we did the last 3 years 3 market investigation references. So one was in the press distribution sector, which concluded with the development of a regulatory framework for a quasi-regulatory framework for this sector. Secondly, in the construction sector, where we have been relying a lot on horizontal common ownership theories, and some of our experts in the field are Jose Azar and Martin Schmaltz. I mean, the people have been very much working on horizontal common ownership. And we are finalizing now a market investigation reference in the fuels sector. We also completed a couple of sector inquiries. We published the final report of the e-commerce inquiry, which is a very extensive, probably the most extensive analysis of Greek e-commerce ever made, more than 400 pages long, and looking to many different aspects concerning products. I mean, we haven't done, in terms of online for services, for instance, online travel agencies, etc. This is something to keep. We have an enforcement activity in this context. I cannot say more about that. But also, we completed the interim report of the sector inquiry in health services and insurance. This is the first time also we looked to the private health services and private health insurance sectors, where actually we focus a lot. A big part of the report is about the use of health data and new technologies, and in particular, the types of anti-competitive conduct that might lead to. It's quite interesting in Greece because we have a quite extensive, I would say, concentration. It's not a concentrated sector, but it's becoming more concentrated the last few years. In particular, we have an important concentration of private clinics under the control of a private fund, which also bought the largest insurance company of the country, and that merger was approved by the European Commission. So in the context of managing a little bit the post-merger type of environment, we started this extensive sector inquiry. And we're all now also completing, and I hope we will be publishing by the end of the year, an interim report in the recycling and market sector inquiry in the recycling kind of sector, if I can use that term. Now, of course, inflation and greedflation has been an important element that we had to deal with. I mean, we like it or not. I mean, there's a lot of public pressure coming also from the government to make sure that competition authority resources could be used to help a little bit in the struggle against inflation. And of course, we have been very much following closely all the important literature that comes out about, greedflation, in particular, the importance of profit-driven inflation, let's put it that way, and assess, if this could, it could raise some competition concerns. So in that context, we have been very much following closely the government's initiative on the so-called consumer basket. That was an initiative promoted by the government to bring the prices down for certain categories of products. I mean, they were at the beginning, there were 50, now there are a little bit more categories of products. Then, we obviously have a supermarkets task force following a market investigation, a sector inquiry on supermarkets. And this supermarket task force does a sort of measurement of vertical bargaining power to understand which part of the value chain there is actually asymmetrical bargaining power. We started a number of mapping kind of initiatives. This is a new power that was provided to us by law in January 2022. So we did mapping in the fuel sector, in the milk, baby formula, cow yogurt, feta and Gouda cheese. Don't ask me why Gouda cheese in Greece. And laundry detergents. And the results of these studies will be published by the end of October. And also what we try to do in this kind of non-traditional way and having a more immediate effect and create some disincentive for price rises, these are not justified. We did comparative price studies between Greece and other jurisdictions in the laundry detergent markets. I mean, for the same companies, the same products, we saw important differences of prices that could not necessarily be explained by transport costs or other costs. In a way, we put it out there. This has created a lot of, publicity, I think a lot of discussion. And we have been following since a little bit the results of that activity, and we saw that there has been an important decrease, almost 30% of the prices of laundry detergents in Greece, the weeks that followed basically this intervention. We just published another one on the price of milk, and we have a number of other products that we'll be publishing in our following newsletter in December. So it's kind of a naming and shaming type of approach that I think is facilitated by the development, and I will discuss very briefly about that, of a infrastructure that we have to follow the prices of more than 61,300 products daily. And we have actually time series with regards to that enables us somehow to assess possibilities of price parallelism, and then on the basis of other obviously data to develop strategies of down rates or other types of activity in order to unveil possible anti-competitive conduct. We also last year published guidelines, or our new Article 1A. So this is a quite unique article in Europe provision, because it's a provision a little bit like Section 5 of the FTC Act, with regards to the prohibition of invitations to collude, as well as certain forms of price signaling. So this is a quite interesting provision, I think. We worked a lot with a group of experts, in particular Joe Harrington, in developing these guidelines, and we have been since promoting these guidelines to companies. We spoke to the Confederation of Industries, and now we are at the phase of actively, enforcing it. So I said over the period of transition has ended. Now, we will start enforcing the article, and on the basis of that, we're developing with our data science team a sort of a mechanism to through AI to scan basically social media in terms of declarations from different companies and company staff, etc., to assess possible infringement of this Article 1A. That comes to the last kind of point of what I want to develop, which is the use of AI and in particular RegTech. We have invested hugely on that. The idea was to become the leaders, or among the leaders in this area. So this is why we completed first in 2020 a comprehensive inception report with the aim to map the use of different computational techniques, big data, AI, machine learning, deep learning by competition authorities around the world. We developed, as mentioned, the HCC Data Analytics and Economic Intelligence platform that now includes and follows the prices as well as quantities for some products of more than 61,200 products and codes of products, basically. And at the same time, we have been using technology-assisted review of data in some of our high-profile investigations. Now I cannot say more, but we finalized basically a long investigation we had. It started a few months after I took over the authority in 2019, in November 2019, in the banking sector. That was probably the largest investigation ever done by the Greek Competition Authority, exploring interbank collusion investigation in different markets. So, and in the context of that investigation, because we collected more than 1 million documents, I mean, it was absolutely phenomenal. We use a lot of and relied a lot on different types of AI, such as graph analysis or neural networks, to basically be able to identify most incriminating type of evidence and help actually our staff. According to our calculus, through the collective application of these techniques, the number of emails that had to be manually reviewed by the HCC employees was significantly reduced by approximately 96%, allowing for a more efficient and targeted review process. So finally, let me say that we have at the same time tried to move a little bit further into the competition advocacy in the public sector, which is something a little bit missing. I mean, there's a lack of competition culture also in the public sector in Greece. We noticed that because there were a number of meetings between the different ministers and various companies, sometimes competing companies, to discuss things like prices and things like that. So we thought that that was problematic, and therefore we issued a recommendation and a sort of a guide, I would say, to which relates to public policy and competition, which reminds the case law that we have concerning state restrictions to competition, and at the same time provides a competition toolkit as well as advice concerning how to organize a meeting with the companies, what to do, what not to do, what to say, what not to say. And I think that is something that we have been promoting a lot in the public sector, as well as to the companies. For the first time, we participated to the Thessaloniki International Fair, which is the largest international fair in Greece. And finally, in terms of work on sustainability, as you know, the law actually was changed to provide us the possibility in January 2022 to provide us a possibility to issue no action enforcement letters for public interest reasons, including sustainability. That's not like a sustainability defense. It's more like no action enforcement letter. We developed a sandbox tool, which was launched. We had already a couple of somehow informal applications. I don't think the crowds are there yet, which is, I think, something we have been somehow agreeing between heads of competition authorities. I mean, it's probably too early to see companies coming in with different proposals, because we had still the ongoing European guidelines on horizontal cooperation agreements. We're still waiting to see the European guidelines on Article 210A concerning the food sector and sustainability, which will be a little bit even more liberal than the horizontal guidelines. So maybe for these reasons, we haven't seen a lot of applications. So we hope to see a little bit more of applications in next year, and so as to be able to use the tool. But by the end of the year, we will be launching and completing the recruitment of a sustainability advocate to the authority, so as to have like the voice of sustainability, someone that is not a competition lawyer, but someone who is more of a sustainability person, to be able for us to take more objectively into account this particular type of value, of sustainability value. Thank you.
Well, thank you very much, Yanis. Thanks to all the panelists here and to Natalie there in Vienna. We haven't forgotten that you're with us. I mean, what a fantastic series of contributions there, and I've got lots of comments I'd like to make, but I think I should restrain myself. Why don't I begin by looking at you, the audience, and asking, does anyone want to put their hand up and to make a comment or ask any questions? It's a wonderful opportunity for you. 5 different competition authorities all in one room at the same time. We've got the boss of the whole show who's going to ask something. Anybody else as well? Put your hand up. Yeah, there's going to be one over there. We'll hear from both of you, and if there's anyone else, I'll hear from you, and then we can distribute the questions amongst the panel. So should we hear from you first? There's a microphone somewhere. Yep.
Thank you so much. Very interesting to hear lots of different views from across Europe there. My question is actually on the back of your talk about technology-assisted review. I'm in the world of that. and we can see huge savings across using technology. But I'd like to hear from the other national competition authorities on the use of TAR, and if you use that on investigations in your fields.
Okay, and we'll hear from Paolo and anybody else as well. Paolo here.
Very quick question to Ioannis. You said that companies can get immunity from criminal charges if they settle. Don't you think that the possibility to get away with criminal charges by settling can be a reason for the lack of success of the leniency program?
Okay. Anything else from the audience? Yes, please, over there.
Thank you. I have just a question on what you see will be the future of enforcement in next years.
Be a little bit more, that's somewhat broad question. Do you mean are they going to stop enforcing, or no, a little bit more about what you have in mind?
I mean, if I see the activity in recent years is more on the digital side, but today I'm seeing a lot of real economy going on. So what will be in next years the activity you expect on the enforcement side?
I mean, we'll go along the panel. But I made the point yesterday that if you look at all the 7,000 decisions over the last 18 years in the ECN, we give an awful lot of prominence to the digital cases. Everyone's fascinated by Google Shopping and whatever. If you start just prosaically going through all the NCA decisions, there's anything and everything is there, including RPM and local bid rigging cartels and whatever. And I assume that stuff will go on forever. Anyway, we'll come back to it, and I'll ask each panelist to respond. Let's start with the tech question. And I think you're really asking about how can competition authorities themselves make use of technology to assist them in their endeavours, and does that include things like cartel screening and so on and so forth? Yeah, okay. Well, let's take that one first. Who would like to go first on that? Elizabeth, you want to? Or and Natalie, I'll come to you. Yeah. Mm-hmm. So, Elizabeth first.
So the Italian authority has an ongoing project on cartel screening. We had it already a few years ago, and which didn't show it to be particularly useful because of the data available on bits were missing from the sort of authorities that collect data. We are, however, reviewing the project as more data is coming in, and we are collaborating with the Authority for Public Work, which is the National Anti-Corruption Authority, and maybe something new will come out of this. I know in Spain they have an ongoing project which they see as very useful, but of course it depends also on what data you have, right? You need bits, especially if you want to use it for cartel screening. We are going to hire data scientists. I think I can mention this. We have already done some investigations which involved the analysis of algorithms, and we're aware that further issues will arise. So the hiring data scientists is a response to this. Yes, so what I can see also, not just for us, but internally, also in our roundtable of panels with other authorities, that in general, the sort of enforcement responding to technology. We've had a lot of discussion on AI and what will be needed and the issues they may arise and how to respond. So in general, I think we are very flexible and moving with the market.
And I think authorities generally across the world are staffing up to have the right collection of human resources to be able to deal with these things, which are very different needs from what one would have needed 20 years ago. Natalie, would you like to come in?
Yes, thank you very much. So on the tech question, I just like to say that apart from costs for like personnel and general IT infrastructure, I mean, investing in our tech capabilities, that's like the biggest financial post within our budget. That's what we really need. We need to be future oriented. So I think for me, also this topic of AI, I think it's cross-cutting. So we are sort of broadening the task for our forensics team and building it into a forensics and data science team, but it's also a cross-cutting issues to our economists. So I think we need to integrate all our know-how to be equipped. But I think we are, at least within Austria, I can say we exchange, of course, with other enforcement agencies, being it in the sphere of the Ministry of Interior or Defense and others. And I think I'm quite confident to say that I think the competition agency is very advanced when it comes to these tools. And I think also the exchange among our European colleagues is useful. So I think competition agencies are pretty much at the forefront of this. Of course, we're also testing AI and experimenting to make it useful for investigations. So we're looking at it from the enforcement perspective, what companies are doing, but of course, we're also looking at it on the efficiency side for our investigations. How can we make use of it? So it's double-sided. Thank you.
On the budgetary issue, I think that's a very interesting point. I mean, clever people cost a lot of money, but Fabienne made the very interesting point that you evaluate your work to see how much value you're providing to consumers on the basis of your budget. And the CMA in the UK, and before it, the Office of Fair Trading, has done that for many, many years, and does the exercise at the end of a year. You know, how much did we cost and what is our estimate of consumer gain from what we have done? And let's say the budget is 50 million a year, and it's quite often been able to demonstrate that maybe the return was in the order of 1 billion or even 2 billion. And it seems to me it's actually a very worthwhile exercise, because you do have to go and negotiate with your ministry, your treasury, whatever it might be, and they're saying sort out inflation. Well, it seems to be quite a good story to say on the basis of this budget last year we saved people that much, so give us twice as much and we can save them twice as much. But anyways, that's the thought. So Fabienne, though, on the tech point.
On tech points, I'm used to say when I began competition law, it was sufficient to be a lawyer. 10 years after, you should be also an economist. And now you also have to be a data scientist, so it becomes difficult for
And
me.
to be able to do open heart surgery, preferably.
Yes, I must admit. But more seriously, we created a digital unit in 2018, and we have, at the moment, 4 data scientists. It's true, I agree with Natalie, it's costly, and it's difficult to recruit them, and it's difficult to keep them. Because, of course, our budget, as I said, is quite small. So, but these 4 people who work in the digital unit are very experienced, very good, and we create a lot of, or we try to create a lot of instruments, the same as Elisabetta mentioned or Natalie mentioned, and we work also with intergovernmental departments. We have a common unit to work on it, and we also work with other agencies in other sectors to try to use these new tools and to be more efficient for detecting, for example, cartels, but not only cartels, also public tenders is an important field. So that's all I would like to say.
Of course, with the tenders, I can see how screening technology could say, you know, this is just very dodgy, all these people coming up with the same. That different from, I think, what Yanis was talking about, where you're just trying to read the economy to understand where the markets are that are failing. That's a very different sort of exercise. Nuno, have anything you would like to add on this?
Sure. I may try to tie the questions, both questions, you know. First, on the technology side, we at the Portuguese Competition Authority are doing some web scraping, so we've got that work done. But going back to the old style cartels and talking about bid rigging, we can use technology to enhance and to promote the search for those cartels. So I do think that screening is a useful tool, behavioral screening, structural screening. So we are trying also to develop this area, trying to find new forensic investigation tools. And from the budget side, I might say that we have access to EU funds. There are European Union funds for us to help to have consultancy and all that. So we've been working in that. We've been working in cooperation with the Spanish CNMC to get some EU funds. The more NCAs we have, the more funds we have access. So we are trying also with the Greek. So yeah, we are trying to promote the use of technology, not only speaking about digital markets. You know, it's a very trendy and glamorous area to speak, you know, all these gatekeepers, and it's very fashionable to be at the conference speaking to that, but let's not forget about the old-fashioned cartels, the price cartels that affect the consumer that feels in their pockets. So we can use technology also to fight those cartels, and we are trying to do that at the ADC in Portugal. Thank you, Richard.
And of course, that's the point that Diana Moss was making yesterday afternoon when I was on the panel with her, that, you know, everyone's talking about digital, all the stuff, but what about all the other antitrust infringements that are still going on, and that they remain important. Now, Yanis, it was you that raised this issue of technology, and then Paolo put a question to you about the criminal regime and leniency and whatever. And I can create a link here because the need for more screening partly comes from the reduction in the number of leniency applications, and then how also does that map over to the criminal offence or whatever. So what thoughts do you have?
Sure, interesting question. Leniency has never been a success in Greece. As we had leniency the last 20 years, we only had 2 leniency applications. So there's a cultural problem with leniency. So that was the main reason also we promoted the whistleblower tool, because it's actually, it's a platform that enables us to completely anonymously, because actually it's not even based in Greece, it's based in Switzerland, to be able to discuss, you know, have exchange documents, you know, have sort of a dialogue with the whistleblower. Now, because leniency did not work, the change that I mentioned, I mean, they added the settlements in December 2019. There was a change of the law for different reasons. It related to the construction cartel that had problems because many of the works, public works in Athens, in the metro, etc., were stopped because of a competition authority's decision. I mean, somehow there was a kind of an issue. So the government decided to enable, basically, to say that settlements will somehow be equated to leniency. We were not positive about that. We thought that it shouldn't be. It's not a good idea to equalize, leniency and settlements. I mean, leniency, there's someone that comes with a new case to you. Settlement, you have already spent so many resources, and therefore, of course, there's a procedural kind of benefit, but still, it's not the same thing. But the government decided that they had to equalize them. But I think this. So to answer your question, I mean, I don't think it had any impact on the leniency application. There weren't many leniency applications before that, but it certainly increased the likelihood of settlements. So, which is, I think, a good thing to a certain extent, of course. I mean, because you need to also have infringement decisions to be credible. Because if you go only with settlements, then you lose your credibility. Now, very briefly about the evaluation of the authority and what you said about direct consumer benefits in the UK. I mean, we do that as well. I mean, 2022, we have less than the French. We had 12 euros for €1, and I gave the objective to my Director General to have at least 15 euros per euro for this year. Hopefully, we'll manage. But I think this is it's actually OECD kind of methodology, and it's extremely, I don't know, not very sophisticated because it only looks to direct consumer benefits. So what we did is we created a small group where Tommaso Valeri also participates, of economists. There's Tommaso Valeri, Christos Giannakos, Nikos Vetas, like Greek economists, and Tommaso Valeri, which I consider him as half Greek. They're basically thinking about other ways to evaluate the work of the authorities, not just direct consumer benefits, also even non-consumer benefits, right?
Yes.
So, and I think we're expecting their report in October, so hopefully, because we plan to use KPIs and then be evaluated by this independent committee, and the report to be sent to the parliament on the basis of that for us to receive a bonus for the authority, like a couple of million euros extra for investments and our stuff. So, and finally, in terms of the future of enforcement, I mean, we focus a lot on digital, but the low-profile digital, if I can call it this way, so online vertical cases, RPM, MFN, EMAPs. Why? Because, I mean, we don't have the resources to bring cases against, like, the mega platforms. I mean, we can bring a case, of course, but not many. And at the same time, we have the European Commission that does it. I mean, of course, we are under Article 38. We are part of the, we have the ability to help, support the Commission in the DMA. But then, we're interested also in areas which are not yet covered by the DMA. I mean, for instance, online travel agencies and this kind of, work, because so far, neither Booking nor Expedia are basically gatekeepers. So, and therefore, we focus a lot of our work, and our future work will be on traditional economy, bid rigging, food sector, transports, and also, I would say, government type of restrictions to competition, which I think is also important to look at that.
Very good. Thank you, Yannis. Elisabetta, did you want to...
Yeah, perhaps just on the leniency, because it was very interesting, the debate going on, especially a year ago, where trends were observed showing a decline in leniency. So there has been across many countries, most OECD countries. So there was a lot of discussion, very international meetings, and we all wonder why that was happening and whether we needed to respond with some kind of a change in the legislation at European level. Somehow, I think we reached not an agreement, but a common perception was in the end that there are many factors that may contribute to the reduction in leniency. It could be, of course, that there are issues related to the rise in private enforcement, and the perception was that this is happening, and if there is more private enforcement, then of course, firms are less inclined to come forward unless they can receive some kind of immunity from private enforcement as well. There was an issue about the reduction in leniency, perhaps linked to the reduction in ex officio investigation. So, of course, the more ex officio investigation you do, the more firms have an interest to come forward, fearing that you will investigate them. We looked inside our authority. That is not happening. Almost half of our bid rigging cases are ex officio, also thanks to the collaboration with public procurers. And it may also be linked to greater uncertainty at judicial level, so it's less worth it. And it may also be linked to the fact that more and more jurisdictions are taking on settlements. And of course, if you can settle, the incentives for leniency may go down. However, I then participated to a meeting, and I recall the Commission mentioning that actually leniency applications are now up. There were, a few months ago, there were twice as much as the previous year and 3 times as much the 2 years before. In Italy, we have criminal convictions in case of bid riggings, but now, thanks to DCN Plus, there is immunity from these criminal sanctions for the immunity applicants. So we are expecting, perhaps, that leniency applications will pick up again.
Okay, thank you, Elizabeth. Now, I'm aware that we have to be out of this room in about 6 minutes, because it's a cinema, and I think they're showing Casablanca at 3:30. Was there a sort of a one-sentence comment you wanted to contribute, or?
For leniency, or yes, maybe.
I thought there was something you did want to come in on. And very quickly, Natalie, very quickly, and then we're finished, okay?
Yes.
Yeah,
Yeah,
very quick.
I just wanted to say that we haven't seen this decline in France for leniency because we have, for example, last year, three applications for leniency. But sure, the big question is private enforcement. It is the big question. And we have also recently immunity for leniency applicants subject to certain conditions. But I don't want to be too long, so I stop there.
Very good. And Natalie, 1 minute, no, less than 1 minute.
Sure, no problem there. Just want to say that to echo France, we haven't seen a decline. I mean, despite being a small jurisdiction, we have had over 120 leniency applications since the inception of the leniency program, and the numbers are not going down. And also, I mean, I've been with the agency since 2009, and I see as much classical hardcore cartels as ever. So yes, there might be a component with algorithms or other tools, or maybe the kind of evidence is different, but the types of cartels, I mean, it's still the same. So I'm a bit skeptical towards the assessment of saying we live in a completely different world. I think it looks a little bit different, but the mechanisms are basically the same.
Okay,
in my view.
I can see a new kind of competition here. We've got the largest number of dawn raids in Greece, the largest number of leniency applications in Austria, the best value for money in France. So Portugal has the last word.
Well, I don't have a trophy to have. My goal is the welfare of consumer at the end. And about leniency, I think there's a global problem that we have to face, which is interaction between competition law and criminal law, because you have to understand, like in some cases, in bid rigging case, in each two cases, one has corruption also involved. And so you have a criminal issue there that stops somehow the use of leniency, because, you know, people can benefit from leniency, but from a criminal law perspective, they don't benefit. So the ICN directive speaks about that in Article 23, 24, and in Portugal we have that problem. So in some cases you don't have leniency because of the criminal issues. So that's
Well, I'm going to give myself the last word, which is to say that we introduced the criminal sanction in 2002, and I was extremely enthusiastic. I agree with Yanis. It was the ultimate deterrent to send people to prison. It has turned out to be a total and absolute nightmare. And the CMA has more or less abandoned the criminal sanction altogether. But we do have company director disqualification, and that is being actively used. It does not require any criminal prosecution. It's a consequence upon a finding of infringement, and that concentrates people's minds as well if they're going to be disqualified as a director. Anyway, look, I think we must bring this to a conclusion, so thank you to the panelists here. Thank you to Natalie. I thought it was a terrific discussion. Thanks very much.
Thank you, Richard.
All right. Thank you so much. And before they kick me out, there are two things that I have to say. The first one is that we are closing the festival now, which means that on Monday we are going to start working on the 24th edition of the festival. So stay tuned. And if you have any suggestion, any topic you want us to talk about, please let us know, and we will take into consideration any recommendation. The second thing I must say, is that I want to thank the partners, all the speakers, all the people that attended the festival, but of course I have great gratitude toward all my colleagues that worked on this project. So please, can you stand up when I call your name? Mohamed? Okay. Livia and Livia, where are they? Okay, they should be somewhere. Clarissa? Alessia? Benedetta? And Gabriele? Emma? Where is she? All right. And last but not least, of course, Silvia, who is the real queen of the festival. Thank you so much, and see you next year. Arrivederci.
Grazie.